The International Criminal Court is now in session. Lord Sion, the Court Panel International at Ongwen.
On 28 February 2024, Trial Chamber 9 of the International Criminal Court, ICC, composed of Judge Bertram Smith, presiding judge, Judge Peter Kovacs, and Judge Chang Ho Chung, delivered the order for reparations to victims in the case The Prosecutor versus Dominic Ongwen. The parties and participants were present both in the courtroom and some followed remotely. The accused, Dominic Ongwen, was following the proceedings remotely. On 4th February 2021, Trial Chamber 9 found Dominic Ongwen guilty for a total of 61 crimes comprising crimes against humanity and war crimes committed in northern Uganda between 1st July 2002 and 31st December 2005. On 6th May 2021, Trial Chamber 9 sentenced Dominic Ongwen to 25 years of imprisonment. On 15th December 2022, the Appeals Chamber confirmed the decisions of Trial Chamber 9 on Dominic Ongwen's guilt and sentence. The conviction and the sentence are now final. On 18th December 2023, Mr. Ongwen was transferred to Norway to serve his sentence of imprisonment. The reparation order hearing was delivered in courtroom 1 at the seat of the court in The Hague, the Netherlands, in the presence, live or remotely, of Mr. Dominic Ongwen, his defense team, the legal representatives of victims, the common legal representative of victims, the trust fund for victims, the representatives of the registry, and the representatives of the Office of the Prosecutor. During the hearing, the presiding judge addressed the victims in this case.
As a result, the Chamber concludes that the direct victims of the attacks, the direct victims of sexual and gender-based crimes, and the children born out of those crimes, as well as the former child soldiers, suffered serious and long-lasting physical, moral, and material harm. The indirect victim of all these crimes suffered moral and material harm. In addition, the entire community of victims suffered community harm, and children of direct victims suffered transgenerational harm. The Chamber notes that due to the limitations that a summary imposes, it is not able to describe in more detail the great suffering and long-lasting consequences suffered by all victims of the crimes for which Mr. Ongwen was convicted. The Chamber notes, however, that acknowledging the victims' suffering, the reparations order recounts in detail the harm they suffered. This should also serve as a satisfaction measure in this case.
The presiding judge further clarified that the reparation proceedings focused on victims who suffered harm because of Mr. Ongwen's crimes of which he was convicted of.
The Chamber underlines that the present reparations proceedings exclusively deal with Mr. Ongwen's duty to repair the harm caused to the victims of the crimes for which he was convicted by this court. They do not extend to individuals beyond the victims of the crimes for which Mr. Ongwen was convicted. The Chamber understands that individuals who have experienced harm as a result of the same conflict in northern Uganda, but are not entitled to reparations in this case, may be confused and disappointed. The Chamber recognizes these individuals and acknowledges their suffering. However, it reiterates that reparations in this case are not designed to rectify all harm suffered throughout the conflict and are tied to the specific harm caused by Mr. Ongwen's crimes. These reparation proceedings, however, do not otherwise affect the rights of victims before national, regional, and/or international bodies.
Regarding the principles on reparations, the presiding judge, Judge Bertram Smith, said that the Chamber adopted the principles as set out in the Ntaganda Reparations Order, as it considered them to be of general application. In addition, considering the submissions of the parties and participants, the Chamber slightly amended the principles related to the types and modalities of reparations and child victims.
Regarding types and modalities of reparation, the Chamber notes that, first, rehabilitation measures may also be aimed at improving the victim's socio-economic conditions. Second, payments that are not proportional and appropriate to address the victim's harm can only be regarded as symbolic and not compensatory. And third, measures of satisfaction and guarantees of non-repetition can also be included as appropriate modalities of reparations. Regarding child victims, considering the extensive manner in which children were affected by the crimes for which Mr. Ongwen was convicted, the Chamber has adjusted the principles on reparations to the extent necessary to ensure that it includes, first, all victims who were children at the time the crimes were committed, or who were born as a result of such crimes, and second, the four principles of the Convention on Rights of the Child and the Child Right Approach.
In regards to the type of reparations, the presiding judge noted that collective community-based reparations as the most appropriate type of reparations to address the harm suffered by the victims of the crimes for which Mr. Ongwen was convicted.
In the Chamber's view, the primary reason why collective community-based reparations are appropriate and necessary in this case is the extent of the harm suffered by the, and can only stress that, by the overwhelming number of eligible victims, estimated by the Chamber to be close to 50,000. While the Chamber understands the desire for individual reparations, it remains convinced, for the reasons described in detail in the reparations order, that a collective award that addresses the entire community of eligible victims will ensure a more efficient, prompt, and practical approach. The extremely large number of victims would make an individual assessment of their harm for the purposes of granting individual reparations or collective reparations with an individualized component resource-intensive, time-consuming, and in the end it would be disproportionate to what could be achieved.
Moreover, regarding the modalities of reparations, the presiding judge noted that the Chamber considered that the only way to address the harms in a concrete, effective, and timely manner is through collective community-based reparations focused on rehabilitation and symbolic satisfaction measures.
Specifically, the Chamber considers that the following modalities should be included. First, rehabilitation measures consisting of collective community-based rehabilitation programs directed at rectifying all types of harms identified by the Chamber, meaning the physical, the moral, material, community, and transgenerational harm. And second, symbolic and satisfaction measures, including a symbolic award of 750 euros for all eligible victims. The Chamber notes that the calculations of the amount of the award are explained in detail in the reparation order. And second, other community symbolic and/or satisfaction measures.
Furthermore, the presiding judge, Judge Bertram Smith, addressed Mr. Ongwen's financial liability for reparations following several factors that the Chamber considered.
The Chamber reiterates that it has awarded, in the present case, collective community-based reparations focused on rehabilitation and symbolic satisfaction measures. Regarding the rehabilitation measures, the Chamber has considered the submissions from parties and participants, particularly from the Trust Fund of Victims, and resolved the discrepancies in favor of the convicted person. The Chamber estimates insofar that the cost of implementing the collective community rehabilitation programs ordered in the present case would amount to approximately 15 million euros. Regarding the symbolic and satisfaction measures awarded, the Chamber notes: as to the symbolic award of 750 euros, again, the calculation of which is explained in detail in the reparations order, the Chamber recalls that this is part of the collective community-based program. As such, it is awarded to the benefit of all eligible victims, without distinction as to their type of victimhood or harm. In order to calculate the amount required to provide this symbolic payment, the Chamber relies on its estimation as to the total number of victims in the case, which amounts to approximately 49,772 individuals, as I have already said. As such, the total amount required to provide victims with the symbolic payment is 37,329,000 million euros. As to the other community, symbolic and/or satisfaction measures, the Chamber considers it fair and appropriate to estimate the costs, which include inter alia apologies, ceremonies, monuments, memorial prayers, reconciliation ceremonies, and so on and so forth, at a total of 100,000 euro. In light of all this, the Chamber estimates that the total amount required to provide the reparations awarded in this case to the victims of the crimes for which Mr. Ongwen was convicted would be approximately 52,429,000 euros. The Chamber is satisfied that setting the amount of Mr. Ongwen's liability for reparations at an amount of 52,429,000 euros is fair, equitable, and appropriate, and takes into account the rights of the victims and those of the convicted person.
In conclusion, the Chamber ordered the Trust Fund for Victims, TFV, to prepare a draft implementation plan, DIP, with the details of the rehabilitation and symbolic measures to be included within the collective community-based reparations awarded. The Trust Fund for Victims, TFV, should submit the DIP for the Chamber's approval within 6 months from the delivery of the reparation order. In conclusion, the presiding judge, Judge Bartram Smith, read out the reparation order.
For the foregoing reasons, the Chamber hereby unanimously adopts the Ntaganda principles with slight modifications regarding the principles related to types and modalities of reparations and child victims, issues an order for reparations against Mr. Ongwen, awards collective community-based reparations focused on rehabilitation and symbolic and satisfactory measures to the direct and indirect eligible victims in the case, estimates the total number of direct and indirect victims in the case to be approximately 49,772 victims, assesses Mr. Ongwen's liability for reparations at approximately 52,429,000 euros, instructs the Trust Fund for Victims to prepare a DIP pursuant to the requirements outlined in the present order, and submit it for the Chamber's approval by 3rd September 2024 at the latest, invites the parties and the registry to provide observations on the Trust Fund for Victims DIP within 30 days from its submission, instructs the registry through the PIOS to design and conduct, throughout the duration of the administrative eligibility process, the required outreach campaign for the purposes of these reparations proceedings, After engaging in consultation with the parties, the Trust Fund for Victims, the VPRS, the OPCV and the country office, instruct the registry through the VPRS to conduct the identification of potential beneficiaries and eligibility assessments pursuant to the instructions contained in the present order, providing within 30 days from the issuance of this order an estimate as to the time it requires to assess eligibility and urgency regarding all participating victims, instructs the registry through the VPRS to commence with the identification of potential beneficiaries as soon as possible and prior to the approval of the DIP, instructs the VPRS and the PIOS to work together to ensure that the administrative eligibility process is completed within 2 years of the present order, finds Mr. Ongwen indigent for the purposes of reparations at the time of the present order, encourages the Trust Fund for Victims to complement the reparation awards and engage in additional fundraising efforts to the extent necessary to complement the totality of the award, and finally encourages the states, organizations, corporations and private individuals to support the Trust Fund for Victims' mission and effort and contribute to its fundraising activity.
After delivering the reparation order, the presiding judge, Judge Bartram Smith, thanked the parties and participants before adjourning the hearing.
This concludes the Chamber summary and today's hearing.
The reparation order decision is not final. The defense and the legal representatives of the victims may appeal this decision. If they appeal the order, an appeal is decided by 5 judges of the appeals chamber, who are not the same judges as those who gave the original order. The appeals chamber may uphold the appealed decision, amend it, or reverse it, and remand the matter to the trial chamber for a new determination.